The call came while you were at work, or in a parking lot, or wherever you happened to be when your life was interrupted, and someone at the nursing home used careful, administrative language to explain that your loved one needed to be discharged. They may have said the facility could no longer meet her needs. They may have said his Medicare benefit had run out. They may have said the bed was no longer available after the hospital stay. Whatever words they used, the message was the same. Your loved one needs to leave. And if that call has already happened, or if you are watching this because you are afraid it is coming, there is something you need to know before you do anything else. Each year, Ombudsman programs across the country document more than 10,000 complaints of illegal or improper nursing home evictions. That number increased nearly 9% from 2023 to 2024 alone. Federal law, specifically the Nursing Home Reform Act of 1987, prohibits facilities from removing a resident except under 6 specific legal conditions. Medicare coverage ended is not one of them. We prefer a private pay resident is not one of them. Most families do not know this. Most families comply. And the nursing home industry has counted on exactly that outcome for decades. By the end of this video, you will know the one sentence that stops an illegal discharge notice in its tracks, and the federal regulation that requires the facility to let your loved one stay while you fight it. The first thing you need to understand is what a legal discharge actually requires, because the distance between what the law permits and what facilities attempt is not a gray area. It is a documented, recurring violation pattern that state and federal regulators have tracked for years. Under federal regulations codified at Title 42 of the Code of Federal Regulations, Section 483.15, there are exactly 6 grounds on which a nursing home may discharge or transfer a resident. The facility can no longer meet the resident's clinical needs. The resident's health has improved to the point that facility-level care is no longer necessary. The safety of other residents or staff is endangered by the resident's presence. The resident has not paid after receiving reasonable notice. The facility is closing, or the health of other residents is endangered by the resident's continued presence. 6 grounds. That is the complete list. Facilities are required to provide at least 30 days of written notice before any discharge, and to specify in that notice which of the 6 grounds applies. That notice must also inform the family of the right to appeal. That requirement exists on paper. It does not always exist in practice. Discharge and transfer complaints have been among the top complaints received by state long-term care ombudsman programs for more than a decade, according to data collected through the National Ombudsman Reporting System operated by the Administration for Community Living in Washington, D.C. These complaints surged after the pandemic and continue to rise. The program documented over 205,000 total complaints in 2024 across all categories. The financial motive is not difficult to trace. Nationally, Medicaid reimbursement rates pay a nursing facility approximately 70% of what a private pay resident pays out of pocket. That gap is the engine that drives illegal evictions. A facility operating 100 Medicaid-funded beds that successfully converts those beds to private pay at $12,000 per month versus roughly $8,400 per month under Medicaid generates an additional $360,000 in monthly revenue. That math runs every time a Medicaid resident's Medicare coverage ends and the transition to Medicaid funding begins. That math is what drives what regulators call patient dumping, which is the practice of sending a resident to a hospital for an acute medical event and then refusing readmission when the resident is ready to return, claiming the bed is no longer available. Many states require nursing facilities to hold a Medicaid resident's bed during a hospital stay for a defined period, though policies vary significantly by state, and some states require no paid bed hold at all. Families need to know their specific state's policy before a hospitalization occurs, not after. And if a facility refuses readmission before any applicable bed hold period has elapsed, that refusal is illegal. The facility knows the rules. Families almost never do. The case of Gloria Single, an 82-year-old woman with dementia, is the most thoroughly documented example of how this plays out. Pioneer House, a nursing facility in Sacramento, California, operated by Long Beach-based Retirement Housing Foundation, sent her to the hospital following an incident in the dining room in March of 2017. The hospital cleared her for return the same day. The facility refused readmission. Her son, Aubrey Jones, filed an appeal with the California Department of Health Care Services and won. The facility was ordered to readmit her. It defied the order. AARP Foundation, headquartered in Washington, D.C., filed suit on her behalf. In 2021, a California court ruled that Pioneer House had violated her rights. In 2023, the same court issued a sweeping final order declaring that any facility's refusal to accept a resident back from a hospital constitutes an involuntary transfer under both state and federal law. Gloria Single never returned to Pioneer House. She died in 2019, separated from her husband of 30 years, while the legal case continued on her behalf. The part of this that most people miss is not the refusal itself. It is that the refusal only works if the family does not appeal, because when families appeal, they win at a rate that the industry does not publicize. The refusal is not a final decision. It is a bet that you will not fight back. What follows next in this pattern explains why facilities are so confident in that bet, and it has everything to do with timing, paperwork, and a specific word in your loved one's admission agreement you have almost certainly never looked at. This kind of information used to require hiring an elder law attorney to find out. If you want to keep getting it for free, subscribing is how you make sure you do not miss the next one. The deeper you go into how illegal discharge actually works as a systematic practice, the more one pattern becomes impossible to ignore. The regulatory framework assumes a resident and family who know their rights, receive proper notice, and understand the appeals process. The industry's actual practice assumes a family in crisis, under time pressure, with no familiarity with federal regulations, who will accept whatever language appears in an official-looking letter and begin making alternative arrangements within 48 hours. That assumption has proven correct often enough to become a business strategy at facilities that prioritize revenue recovery over compliance. Here is the structural reality. Nursing home chains with high concentrations of Medicaid residents face perpetual pressure from ownership structures to increase revenue per occupied bed. Discharging a Medicaid resident and replacing them with a private pay admission is not a compliance failure at those organizations. That is not a coincidence. That is a business model. The 10,000 families per year who receive those discharge notices and do not appeal are not failing to protect their loved ones because they do not care. They are failing because no one told them the notice was potentially illegal, the appeal is free, and the law requires the facility to let their loved ones stay in place while the appeal is decided. Aubrey Jones brought his mother's case to a California court and won a ruling that changed state law. Most families never make the first call. Everything before this point is what facilities count on your family never knowing when that discharge letter arrives. What follows is what they are genuinely afraid you will do with it. The sentence that stops an illegal discharge in its tracks is this: "We are filing an appeal under 42 CFR 483.15 and invoking our right to remain in place during the appeals process." You do not need an attorney to say it. You need to say it in writing within the appeal window specified in the discharge notice, which the notice is legally required to include. Here is how to execute the complete four-step protocol. First, obtain the written discharge notice and read it for the stated legal basis. The notice is required by federal law to specify which of the 6 legal grounds applies. If the stated reason is not one of the 6, you have documented evidence of an illegal discharge on the face of the notice itself. This step takes approximately 30 minutes and costs nothing. Second, File a written appeal immediately with your state's Medicaid agency or the Administrative Hearing Division named in the notice. Federal law requires the facility to allow your loved one to remain in their room while the appeal is pending. That protection is called appeal in place, and it means the facility cannot physically remove your loved one while you fight the discharge. Filing takes approximately 1 hour. There is no cost to file. Third, contact your state's long-term care Ombudsman program immediately. The Long-Term Care Ombudsman is a federally mandated advocate available at no cost in every state, accessible through the Elder Care Locator, a free federal directory operated by the U.S. Administration on Aging. The Ombudsman can accompany your family to hearings, document the violation, and escalate to state regulators if the facility retaliates. Contacting the Ombudsman takes approximately 15 minutes. Fourth, if your loved one was sent to the hospital and the facility is claiming the bed is gone, request in writing from the facility a written copy of their bed hold policy and your state's Medicaid bed hold policy. Your state's bed hold policy is a matter of public record, available through your state Medicaid agency. If the facility refused readmission before any applicable bed hold period elapsed, that refusal is illegal on its face, and the Ombudsman and state Medicaid agency both have authority to compel readmission. Those 4 steps, completed in sequence, take approximately 2 to 3 hours total and cost nothing. The average cost of a private pay nursing home placement that families arrange under pressure after complying with an illegal discharge notice is $12,000 per month or more. 2 to 3 hours of paperwork versus $12,000 a month. That is the math the facility is counting on you not doing. Before this video, you were the family who received a letter with official language and assumed it meant what it claimed to mean, because why would a licensed facility send a document that violated federal law? That assumption is what the industry is built on. You are now the family who knows there are 6 legal grounds for nursing home discharge, that an appeal freezes the process entirely, that a free federal advocate exists to stand next to you in the hearing room, and that the facility's confidence in that discharge notice was always a bet on your silence. If you are currently navigating any of this, and something in what you just heard matched a situation you are currently navigating, share it in the comments, because you are not the only one, and your experience is evidence. Share this with anyone in your family who is dealing with any of this. And if you want to stay ahead of the industry rather than behind it, subscribe. The next one is something most families find out too late.